State courts are an integral component of any state government. California's courts are meant to ensure that the state's population is guaranteed due process of law and that the other branches of government in the state operate within the scope of state laws, as well as the California Constitution and the United States Constitution. This video will examine how California's court system is structured, the functions it performs, and how judges are selected for the courts. California's courts are structured into three distinct levels or tiers: superior courts, courts of appeal, and the California Supreme Court. The first level of the state court system is the superior courts. These are the courts with the largest workload because they act as the state's trial courts. Trial courts are sometimes referred to as courts of original jurisdiction because they are the first or original courts to hear the case. Trial courts render verdicts based on the facts of the case. As such, this is the level of the court system with juries, whose job is to evaluate the evidence presented at trial. Superior courts hear both criminal and civil cases, in other words, both crimes against the state as well as legal disputes between two parties or individuals. These courts hear cases involving violations of state and local law. Violations of federal law are heard by federal courts, not state courts. Superior courts receive roughly 7.5 million cases per year, but the majority of these cases involve traffic infractions, which are resolved relatively easily. Nevertheless, the approximately 2,000 Superior Court judges have an enormous workload that makes the timely administration of justice very difficult, especially in the wake of budget cuts made to the court system as a result of the Great Recession. Finally, these courts are broken down along county lines, with the size of each county's superior court varying by population size. Los Angeles County, for instance, has nearly 500 Superior Court judges, while Calaveras County has only 2. The middle tier of the state court system are the courts of appeal. The main job of these courts is to review decisions made by the superior courts, and in some cases to review public agencies that have quasi-judicial functions, like the Workers' Compensation Appeals Board. The courts of appeal are organized into 6 regional districts, with each district having a presiding justice and at least 2 associate justices. For instance, the first district, which covers San Francisco as well as the East Bay and the North Coast, has 20 justices serving on that court. Overall, there are 105 courts of appeal justices in the state. Each case heard by the courts of appeal is heard by a 3-judge panel. The job of these panels is to review issues of trial procedure to make sure the case was handled properly by the Superior Court. They look for errors of procedure or incorrect interpretation and application of the law at the trial court level. They're not meant to review or rehear or reevaluate the facts of the case. This type of review of a lower court's decision means that the Court of Appeals has appellate jurisdiction rather than original jurisdiction. Finally, the last level of California's court system is the state Supreme Court. Mostly this court has appellate jurisdiction, reviewing decisions of the courts of appeal. One exception to this is death penalty cases, in which the Supreme Court directly takes up review of the trial court's decision. The Supreme Court is the only level with judicial discretion, meaning the court can select the cases it wishes to hear. With the exception of death penalty cases that get automatic review, the Supreme Court actually rejects most requests for appeal, allowing the opinions of the lower courts to stand. The Supreme Court is made up of 7 justices, led by the Chief Justice. Shifting now to a closer consideration of the functions of state courts, I'd like to highlight a passage from your reading in Democracy in California, in which the authors quote Abraham Lincoln, who said about the court system that judicial decisions have 2 uses. First, to absolutely determine the case decided, and secondly, to indicate to the public how other similar cases will be decided when they arise. For the latter use, they are called precedents. So that first use Lincoln mentions is pretty well understood. Courts determine the case decided. They resolve criminal complaints and civil disputes. But that second use is also critically important. Courts set precedents by interpreting the law and Constitution in particular, specific real-world situations, thereby giving guidance about how similar cases ought to be decided in the future. Included in this precedent-setting power is the power of judicial review, which is the ability of the courts to strike down laws passed by the legislature, initiatives approved by the voters, and actions taken by executive branch agencies as being unconstitutional. For example, as you're reading details, the California Supreme Court struck down Proposition 22, which was passed by the voters in the year 2000, defining marriage as being exclusively between a man and a woman. The court ruled that this violated gay couples' fundamental constitutional right to marry. This ruling was an important example of the court using what's called independent state grounds to reach its ruling. This means the court reached its decision based on its interpretation of California's state constitution, not the United States Constitution. At this point in time, the federal courts had not yet recognized the rights of gay couples to marry under the United States Constitution, but state courts can determine rights and citizen protections that go beyond federal rights under the provisions of state constitutions. In terms of how judges are selected to California's judiciary, all judges appointed to a position must have been a member of the California State Bar or a judge for the previous 10 years. Additionally, all potential judges being considered for appointment by the governor are evaluated by the State Bar's Commission on Judicial Nominees Evaluation. This commission is made up of both attorneys and non-attorney members of the public. It rates potential judges as either exceptionally well qualified, qualified, or not qualified. Its evaluations are not binding, but it provides important information to the governor in the selection process. At the Supreme Court and Courts of Appeal levels, all justices are appointed by the governor. These appointments must be confirmed by the Commission on Judicial Appointments, which is made up of the Attorney General, the Chief Justice of the Supreme Court, and the presiding justice of one of the Courts of Appeal. Once confirmed, the justice takes their seat on the bench, but must stand for retention at the next election. In this retention election, the justice stands alone on the ballot, and voters are simply asked whether that justice should remain on the bench or not. With very few exceptions, justices are usually retained, and they serve 12-year terms before having to face voters again. And there are no term limits for California judges. Things work somewhat differently at the Superior Court level. Here, judges serve 6-year terms with no term limits. They are elected by county voters in competitive, nonpartisan elections, meaning they can be challenged by another candidate. But if a sitting judge does not receive an opponent, then the election is canceled and the judge serves another term. In fact, this is the norm. Most seats on superior courts change hands when a judge steps down in the middle of their term. And when this happens, it's the governor who gets to fill the vacancy. So an important thing to keep in mind is that at all levels, the governor plays a predominant role in choosing who gets to serve on California courts. California judges enjoy pretty high job security. They're very rarely removed from office against their will, but there are several mechanisms in place for removing judges. At the Supreme Court and Courts of Appeal levels, judges can be removed by losing a retention election if a majority of voters votes no on the question of whether the justice should receive a 12-year term. This happens very rarely, but it can have a dramatic effect when it does occur. For instance, in the mid-1980s, Chief Justice Rose Bird and two associate justices on the Supreme Court lost their retention elections due to their opposition to the death penalty. This allowed Governor Deukmejian to appoint 3 new Supreme Court justices, dramatically shifting the political balance of the court. At the Superior Court level, judges can be ousted in a competitive election when they run for a new term. Incumbent judges are very rarely beaten, but it does occasionally happen. Also, judges can be recalled from office, just like the governor can be recalled. Again, this is a rare occurrence, but we do have a recent example. In 2018, Aaron Persky became the first California judge recalled in over 80 years. He was the judge who presided over the Brock Turner sexual assault case, giving the Stanford swim team member what was widely considered to be an egregiously light sentence. Finally, the Commission on Judicial Performance reviews ethics complaints against California judges and has the power to remove judges who are found to have committed serious misconduct.